Datuk Speaker, I beg to move that the Land Court Amendment Bill 2018 be read a second time. Datuk Speaker, today is a historic moment for the native of Sarawak. Why? Because we're finally going to see the light of the day in respect of native land right on Pamakai Menua Pulau Galau or territorial domain with the tabling of this amendment bill. Datuk Speaker, the landmark outcome of this proposed Land Court Amendment Bill 2018 is to enable native communal title in perpetuity to be issued over an area to be described as native territorial domain. This is a very significant proposal by this government under the leadership of Yang Amat Berhormat Ketua Menteri Datuk Petinggi Dr. Haji Abang Abdul Rahman Zohari bin Tun Abang Haji Openg. Most government where indigenous community exists only give usufructory right to their inhabitant on area traditionally occupied by them. Here in Sarawak, under the Gabungan Parti Sarawak government, territorial domain is to be given the force of law and legally recognized as having a proprietary right. The document of title will be issued in perpetuity to this community concerned to protect their territorial domain. Datuk Speaker, this nullifies the view expressed by some so-called champion of native right, keyboard and armchair critic in Sarawak Pakatan. They were all driven by their own selfish and malicious political agenda. Their contention that Gabungan Parti Sarawak is only giving usufructory right to native territorial domain and thereby eroding the native of their native customary land is totally misleading and mischievous. The proposed amendment proved them all totally wrong. Datuk Speaker, for the native of Sarawak, land is regarded as an important part of their livelihood. Their custom, their culture revolve around their land, which are their heritage, passed on and inherited from generation to generation. In some cases, Datuk Speaker, most importantly, the native rely on the land for farming, foraging for food, hunting, fishing, as an important source of material for domestic purposes. Because of this cultural significance, they have very strong sentiment and attachment to their land. By adopting the Taurian system for the state land administration system, these cherished customs and practices were not all incorporated into our land law for the creation or acquisition of ownership and proprietary right to land which the native have long regarded as their ancestral land. Specifically, our written law did not expressly stipulated the system of custom Pamakai Menua and Pulau Galau or the equivalent native territorial domain of other communities, and thus this has affected its recognition. The shortcoming in our law is manifested in the judgment of the Federal Court in the case of Director of Forests, Sarawak, and State Government of Sarawak, and Tur Masandah, Anak Tabau, and 7 others, which was delivered on 20th December 2016. In this case, the Federal Court has ruled that the native custom of Pamakai Menua in Pulau Galau, although practiced by the Iban communities, have no force of law in Sarawak. As a result, the claim by Tur Masandah and his anak biak to ownership right over land, which according to the custom is their pulau, was dismissed by the Federal Court. The Federal Court has also ruled that the practice of Pamakai Menua in Pulau Galau was never recognized to have created customary right to land by any of the laws passed by or during Brooke era or by the state legislature. Pamakai Menua in Pulau Galau or its equivalent custom of other natives are also not expressly provided for in any of the codified native adat. The Federal Court decision presented the state government with the opportunity to review the existing law relating to the acquisition of right to land based upon the custom of native community in Sarawak. Through this review, any legal impediment to all the native community to lawfully acquire proprietary right in land would be addressed, to meet the expectation of all native communities to get legal recognition of their right to land acquired in accordance with their own customary law. The judgment of the court, APEC court of this country has a profound impact on the right of the native, which, in accordance to their custom, is their land. Leaving the judgment as it stands is not an option. Datuk Amar Speaker, consequently, the state government formed a special task force on territorial domain, which I have the honor to chair. The task force was assisted by the working committee chaired by Deputy State Secretary. This task force and the committee met numerous times and engaged with various stakeholders over the past year to come up with comprehensive solution. At the same time, Majlis Adat Istiadat was tasked to consult and obtain the views of different native communities in their respective concept, custom, cultural practice, and adat on native territorial domain. This consultation culminated into a special conference for native community leaders held on the 24th, 25th January 2018 in Kuching. The conference resolution and recommendation were forwarded to the state government, which later formed one of the bases to amend certain provisions of the land code, which are now proposed to be incorporated in this amendment. The task force, after engaging with various stakeholders, native community leaders, and relevant state agencies, recommended to the government that the land code be amended as proposed in this amendment bill. The amendments are necessary to give the custom and practice relating to territorial domain the force of law. Under the bill, we use the term native territorial domain instead of pemakai menua on Pulau Galau for inclusiveness, because the practice relating to native territorial domain is not only practiced by the Iban, but also by all other native communities in Sarawak. In the case of Ramli Kawi and Superintendent of Land and Survey, the court have also recognized the concept of cari makan, or the Malay equivalent to pemakai menua in Pulau Galau. Thus, this amendment is inclusive and relevant to all the native. Datuk Amar Speaker, it must be noted that although the dissenting judgment of young Arif Zainul Ali in the Tuai Rumah Sandah case give legal recognition to pemakai menua in Pulau Galau, such right is only limited to user-factory right. This means that the native have the right to only use the resources within the Pulau Galau and pemakai menua for their livelihood, but they do not have any legal ownership, any property right of the land within those areas. Datuk Amar Speaker, this Land Court Bill 2018 will not only recognize but also give legal effect to the territorial domain. Clause 2 of the bill, through the definition of native communal title, expressly provided that a title in perpetuity will be issued in accordance with Section 6A of a native territorial domain, and that such native communal title shall be held to be a title under the Land Code. This means that the right under the native territorial domain is a statutory proprietary right and not just limited to usurpatory right as recognized under common law and the decision in Tuai Rumah Sandah case. Datuk Amar Speaker, the main feature of the bill, among the main feature of the bill are right to land may be created by native to access to the area within, conjoining, or adjacent to the native customary land created under Section 5 of the Land Code if usurpatory right were exercised by the native prior to 1st January 1958. The term usurpatory right is merely descriptive of the customs and practice which would be legally recognized by the amended provision to establish ownership right to the territorial domain. The custom and practice under definition of usurpatory right are similar to the custom of pemakai menua Pulau Galau of the Iban community. These customary practices are now given recognition under the term usurpatory right. The area, Datuk Speaker, where such right has been created will be known as native territorial domain, over which a native communal title for a term in perpetuity will be issued. Such title will be issued to any person or body of person to be held in trust for the native community. The native communal title would be issued for the native territorial domain, and the land may be used for agriculture purposes or such other purposes as may be approved by the Majlis Masyuarat Kerajaan Negeri. This means that the land may be used not only for foraging for food or hunting and a source of timber for domestic use, but also for in usage coming within the term agriculture purposes as defined in Section 2 of the Land Code. Since the land would be for the exclusive use of native community, members of the community will have the prerogative to determine among themselves the usage for their native territorial domain. But if they decided that the land be used for a purpose other than agriculture purposes, they were to apply to MMKN for a change of use. This concept of native territorial domain and the issuing of native communal title applies to all native communities in Sarawak who have right to a native territorial domain. In view of this, the custom of any particular community is not used in the description of the area which would be declared under the new provision as a native territorial domain. Indeed, the new term, native territorial domain, and usufructuary right have relationship with the custom of Pulau and Pemakai Menua of the Iban communities. The native communal title is included in the definition of document of title so that proprietary interest of a native territorial domain is recognized. Upon registration of the native communal title, the proprietary interest is that title will be indivisible by virtue of provision of Section 132 of the Land Code. In accordance with the custom that the land is their heritage, it is proposed that the communal title, which include any interest thereby conferred, should not be assigned or transferred to any person who is not a member of the native community therein. Any land under native customary land right under Section 5 or native territorial domain under the proposed new Section 6A of the Land Code would be expressly excluded from any provisional lease under the amended Section 28 of the Land Code. Datuk Amar Speaker, the most challenging issue before the task force is to recommend the size of the native territorial domain. After lengthy discussion and debate, it was agreed that Section 6A should provide for a limit to the area that may be claimed as native territorial domain. That area was determined to be 500 hectares or 1,250 acres. Datuk Amar Speaker, the recent federal court case of Ter Mahnyutan and others, and TH Holding and others, also had adverse implication on native customary right to land in Sarawak. The issue in Ter Mahnyutan case involved claim of native customary right within an area over which a provisional lease had been issued to a private company. The court ruled that while claim of native customary right are proven, the rightful claimant are only entitled to be paid compensation but could not claim back the land since the provisional lease was later registered as a lease in the land office, thereby conferring indivisibility of title on the registered owner thereof. To address the problem arising therefrom, the Mahnyutan case, the proposed amendment also introduced the principle of deferred indivisibility for any provisional lease issued under Section 28 of the Land Code. This amendment will further safeguard the interests of the native over native customary land and right over national native territorial domain to ensure that land under such right of any native would not be included in any area intended to be covered by a provisional lease. It is thus proposed that Section 28 of the Land Code be amended so that upon completion of the final survey only of the land covered by provisional lease, land held by native customary right or within a native territorial domain must be excluded from the provisional lease. In other words, the provisional lease does not enjoy the statutory protection or the principle of indefeasibility of title under the torrent system until and unless a final survey of land to be alienated has been completed, and B, all land held by native under native customary right by virtue of Section 5 of the Land Code and of land under a native territorial domain have been excluded. When this bill is passed, a rule will be made under the proposed Section 213 (1) to ensure that once a claim for territorial domain has been made under the Section 6A, an endorsement would be made in the land register to the effect that the area may be declared a native territorial domain and may be issued with native communal title. This would ensure that the area would not be alienated or issued with title to any third party. The amendment also confers powers on Majlis Masyarakat Kerja Negeri to make rules relating to native territorial domain. To facilitate the implementation of this new concept and to regulate the issuance of native communal title for native territorial domain and the registration, proprietary interest in other related matters. Datuk Amar Speaker, this proposed amendment would address the issue of non-recognition of some native custom by the law of Sarawak relating to the creation of right to land as highlighted in the majority and minority judgment of the Federal Court. It would improve the land administration. It would reinforce the statutory safeguard for native customary right to the land. I must also reiterate that this amendment are meant to enhance the protection for the right of all native community to land and should eliminate dispute between natives and other parties frequently accused of encroaching upon their native customary land. Further, the frequent complaint of provisional lease being issued over land belonging to native has been addressed by an amendment to Section 28. While the concept of using provisional lease before the final survey of land to be alienated is completed is retained, the new amendment should eliminate the incident of native customary land and land under native territorial domain being included in the provisional lease. With this amendment to Section 28, this complaint by native community have been addressed, and the land officer must comply with this new provision when issuing provisional lease. Datuk Amar Speaker, two other amendments are proposed, namely, one, to enable officers authorized by the Director of Land and Survey to have the power of investigation, which they currently do not have in respect to offences under the Land Code. Number two, to repeal those amended provisions in the Land Code under Land Code Amendment Ordinance 2000 Cap 878, which have not been brought into force. These amended provisions are no longer relevant due to the changes made to the Land Code, which would be brought about by the amendment of the bill. One significant effect of this repeal is the reinstatement of Section 5(2)(f) of the Land Code, which was deleted by 2000 amendment. Section 5(2)(f) of the Land Code was a general and saving provision allowing for creation of native customary right over land as may be recognized under the law. There was much uproar among the native community when Section 5(2)(f) was deleted by the 2000 amendment, as it was perceived to be an attempt to remove and restrict their right to create customary right over land. With this amendment, this provision has now been reinstated into the Land Code. The explanatory statement to the bill explained the legal implication of the bill. Datuk Amar Speaker, the said proposed amendment to the Land Code by the bill is also in line with the obligation imposed on the government to give due recognition and protection to traditional land and territories of indigenous people which they have traditionally owned or occupied, as specified in Article 26 of the United Nations Declaration on the Right of Indigenous People, which were adopted by the United Nations General Assembly a few years ago and supported by Malaysia. Datuk Amar Speaker, I must explain why we cannot accept and cannot support the Land Court Amendment Bill 2017, which was much publicized and viral time over time, sought to be introduced by member of Baklalan as private member bill in the last D1 sitting 2017. The proposed member bill sought to amend Section 2, merely adding definition of communal land to mean native customary land and appropriate domain created according to the custom of native of Sarawak. Secondly, amending the definition of customary law to mean custom, body of custom, practice of the native community in which the law of Sarawak give effect, including custom of land territory. That is the proposal. As I've stated earlier, the issue on the native territorial domain is very, very complex. In the private members' bill proposed by member of Baklalan is merely melepas batuk di tangga, did not quite deal with the subject in a comprehensive and in-depth manner the way the Land Court Amendment 2018 does. The bill merely is a token gesture, an attempt to get political mileage, and yet this bill, yang bermakna Baklalan bill, did not seek to confer any property right on the territorial domain. And yet the main statement is today totally different. Did not provide for the issue of title to the territorial domain. Did not grant title in perpetuity to the territorial domain. Did not provide for exclusion or carving out of NCR territorial domain from the provisional list, as now provided for in this bill, in this amendment. Datuk Amar Speaker, I must reiterate that the subject of this amendment bill is to give customs and practices of native territorial domain the legal force. This is further strengthened by granting native title in perpetuity. This is the solution that the state government resolve this controversy on the territorial domain issues. Secondly, this amendment also placed in principle of deferred indivisibility in relation to provisional leases. These are the goodies that was announced by Yang Mohamad, Chief Minister, at a speech while officiating State Gawai 2018 on 26 June 2018. Datuk Amar Speaker, after the Director of Forest Sarawak and Anor and Tur Masandah, Davao and others case, whereby the Federal Court ruled that the native custom of Pamakai Menua Pulau Galau has no force of law, we have two options to respond to the Federal Court ruling. One was to allow the controversy to be resolved in court. Second, consider a political solution. At that time, Allahyarham Peng Sri Haji Adnan Satim then was determined and committed to respond through the option 2, to go for possible political solution. Therefore, he has directed us to pursue option 2 and find a possible political solution to resolve the issue revolving, Pamakai Menua and Pulau Galau as reflected in the case of Director of Forest in the Zumasana case. Datuk Amar Speaker and members of this August House, even on his deathbed, Allahyarham Peng Sri Adnan bin Satim still reminded me to settle the issue. That shows of his commitment to resolution of this issue and his support this issue in a matter of political resolution. Therefore, it is appropriate for us today to record our appreciation to Allahyarham Peng Sri Haji Adnan bin Satim for his steadfast support to pursue the issue until today. I hope he knows we are passing the bill. Datuk Mas Speaker, we also record our appreciation to Yang Amat Berhormat Datuk Petinggi Dr. Abang Haji Abdul Rahman Zuhari bin Tun Abang Haji Openg for his unyielding support, advice, encouragement and guardian that enabled this bill to be finally tabled in this August House. Yang Amat Berhormat Datuk Petinggi has heard the voice of the people and responded positively with a single objective, that is to find solution to this issue. Datuk Mas Speaker, the route to this bill to reach this August House has been very challenging. The task force and working committee had to do all the balancing act. We have to be inclusive. Therefore, I appeal to all not to politicize the issue, but focus on finding solution to the problem.